All right, then the next case is going to be State versus Joseph Daniels. This is yes. All right, in the matter of the State versus Joseph Daniels, this is the sentencing hearing. First thing I'd like to do is to take up the issue of the motion to quash a subpoena, and I'm going to allow the State to argue. It's the State's motion to quash, so let's let the State argue its motion, and then we'll hear from the defense.
Your Honor, in this particular case, a juvenile who's also a witness in the trial has been subpoenaed going by the initials AN. The defendant, through his attorney, had issued a subpoena to the caretaker of AN, and I'm not for sure whether that subpoena has been served or returned. But regardless, in this case, we filed the motion to quash because the potential witness testified at the trial in this matter, and his testimony, he was examined by the State as a State's witness, and then the defense was given wide latitude to cross-examine the juvenile. In fact, was a lengthy cross-examination. Sentencing hearings are not wide open to just any witness. The testimony has to be relevant to the sentencing factors at hand. It is the State's position that this particular witness, who is a juvenile, would not have any testimony that is relevant to the sentencing of the defendant in this case, and without a showing of relevance, we'd ask that the subpoena be quashed.
Mr. Lockett, you have requested a subpoena for this minor. Is that correct?
Yes, Your Honor. The sentencing hearing includes many enhancing and mitigating factors that the court looked at. A large percentage of them involve the circumstances around the alleged crime to start with. At trial, the strategy is not to ask questions in regard to sentencing factors, but only in regard to the issue of guilt or innocence. The enhancing factors in this case involve, number one, alleging the defendant was the leader in the commission of an offense involving two or more criminal actors. We should be allowed to examine this witness on what actors he maintains were involved in this. Also, the circumstances that the defendant treated Joe Clyde Daniels with exceptional cruelty during the commission of the offense. I think I can bring out testimony that this witness will say he saw no evidence of exceptional cruelty. I should be allowed to ask him that. The defendant had no hesitation about committing a crime when the risk to human life was high, is one of the factors that is set out. This witness is alleged to be a fact witness to what happened, the circumstances, and in regard to what happened with Joe Clyde Daniels after the alleged killing. All those are factors that go to sentencing, not just enhancing factors, but I think that he will give testimony that supports that it's unlikely that the defendant had a sustained intent to violate the law in this case, and other factors, but I don't intend to go through everything I think we can show through this witness, but he's a fact witness in the sentencing hearing, and how the crime took place, what happened after the crime, are all factors the court can look at, and we didn't cross-examine him on sentencing issues at trial.
Now, if I could respond briefly, let's not forget that at the trial, Mr. Lockhart alleged that this juvenile was either a co-conspirator or an actor in this criminal offense, alleged such on the record. And, Your Honor, I had requested for Mr. Lockhart to show law, and as did the court, to show any case in the state of Tennessee in which an 8-year-old child has ever been charged as an accessory or an accomplice. And to this day, Mr. Lockhart has not.
What does that have to do with the sentencing hearing?
Judge, it goes to the motivation of the defendant to, again, have an opportunity to cross-examine a juvenile. I mean, that's the point. All of these factors he claims are relevant to the sentencing hearing are actually facts that have already been testified to at the guilt phase. And he cross-examined this child for a lengthy period of time.
Let me see the most recent filing. Imprisonment. So the only question is whether are those remaining offenses. This sentencing hearing will not affect the life sentence that Mr. Daniels has facing him and that will be imposed today. This ruling will only affect, and this sentencing hearing will only affect those additional charges, and the question of whether those charges run contemporaneously with or run consecutively with. Now, if Mr. Lockhart wants to concede that these additional charges could add time to the defendant by being run consecutively, I'll certainly reconsider my ruling. But under the circumstances, as I examine the law, and I'll allow both sides to have an argument on that, consecutive sentencing may not be available in this case. If the defense wants to argue that consecutive sentencing is going to be available, then I'll reconsider my ruling, and we'll think about bringing the child in to testify about those things. Otherwise, whatever sentence I give him, if I give Mr. Daniels the maximum sentence on each one of these additional charges, but I cannot run it consecutively to the life sentence he's already automatically going to receive, then exactly how is your client prejudiced, Mr. Lockhart, with denying you the opportunity to put this child under oath and on this record, when that sentence necessarily would run concurrently with the sentence of life in prison?
If the court and the state are willing to stipulate that there will be no consecutive sentencing in this, then I agree. If they're just going to agree to a life sentence and everything else run concurrent.
No, I'm not foreclosing anyone. I'm just arguing, is that the reason why you feel it could be important?
Absolutely, Your Honor. Right now, I don't know that the state, I assume they filed enhancing factors. I assume they're going to try to get him sentenced to the maximum in the range on these offenses and ask at least that a couple of them run consecutive. Now, if they're willing to say now they're not going to do that and everything will be concurrent, then there's no bone to pick, so to speak.
Well, and I want to hear from the state, because there's a specific statute on consecutive sentencing that requires certain conditions to be met, and I assume experienced trial lawyers such as state and the defense are aware of the case law that requires what's required for consecutive sentencing, but we'll hear from the state about that. So.
Dangerous acts that were committed by the defendant were previous to the juvenile's birth. He would have no recollection or knowledge of that. Secondly, Mr. Lockhart's argument to the jury was that his client had mental health issues. I mean, that's not disputed. I mean, again, that goes against calling the juvenile as a witness. Nobody is disputing that the defendant had a mental health issue. But also what's not disputed is that the defendant was competent not only to understand the seriousness of the offense and appreciate what he did, but also to stand trial. So that also is not an issue. But we will be asking for consecutive sentencing on the final 2 convictions.
All right, in view of the fact that the state wants to seek consecutive sentencing, then I will reserve ruling on the motion to quash until after I've heard the proof on the state's case, and then I'll determine whether or not it rises to the level that I think this young man's testimony could or could not assist in the court in making that decision. The defendant has the right to put on the proof they wish, but if there is ample proof that sustains the same issues, then it would not necessarily require that this young man be required to testify. So I'll reserve my ruling on the motion to quash until such time as the state has concluded its case, and then we'll make a determination. All right, the state may call its first witness.
Your Honor.
In the event that the court does not quash, I think it would be best to make sure the witness can be here and be available.
If we finish the state's proof, and for some reason that I rule that he should be allowed to be called, then we will adjourn this hearing and come back to it on another time when he can be available if for some reason he's not available.
Yes, Your Honor.
Call your first witness.
Your Honor, the state calls John McGranahan.
Do you solemnly swear or affirm the testimony you give in this case to be the truth, the whole truth, and the truth, so help you God?
I do.
Mr. McGranahan, will you state your full name for the record, please?
My name is John Wesley McGranahan,
And will you spell your last name?
McGranahan.
And Mr. McGranahan, what is your employment?
I work for the Tennessee Department of Corrections, Probation and Parole.
And what do you do for the Department of Probation?
I am a probation parole manager supervising 6 employees.
Thank you. And in this particular case, what was your job?
In this particular case, I was asked to do or prepare a pre-sentence report in the Joseph Ray Daniels case.
And did you do so?
I did.
And has the defense been provided with a copy of that report?
Yes.
May I approach the witness, Your
You
Honor?
may. I have the original, is that the one? It even has the water stains on the back side of it.
Yes, sir.
We'll mark it as Exhibit 1.
So, Mr. McGranahan, just kind of issues with with this report. What exactly is a pre-sentence report?
What I describe it is like a biographical history of the defendant as well as information about the offense itself.
And what do you do to obtain this information?
First, I do an interview with the defendant. I will research the information he has given me. I will get a personal questionnaire from him. I will interview other people involved, family, for example, education, employers. I will consult NCIC for prior record history, things of that nature.
Okay. And let's start with that prior record of the defendant. Were you able to find any prior convictions as an adult?
No, I have not.
Okay. Were you able to ascertain information about the defendant having been charged with a felony as a juvenile?
I was told, but I was not able to secure any juvenile records on him.
Okay. And if I could, I would refer you to page 10 of the sentencing report.
Yes.
And Mr. McGranahan, I'll ask you to look at what has been, what I've highlighted as paragraph 2.
Yes.
Did you take a statement from the defendant in gathering some of this information?
I did.
And what did the defendant tell you about a prior charge as a juvenile?
He did admit that he was had an aggravated assault against his aunt.
Okay. And what did the defendant tell you that his adjudication or result of this conduct was?
He told me he did go to juvenile court and did receive a 6-month restraining order upon him.
Did he discuss the facts of the case at all with you?
He just elaborated that the offense involved his aunt allegedly was drunk and was saying things, specifically what, he did not elaborate, that caused him to get met, what he said, as bad as hell, and it resulted in him pushing her down onto the floor.
Okay, so the defendant's statement was that he got, quote, and I'm reading from your report, which is on the screen,
Yes.
mad as hell, and that's in quotation marks,
Yes.
that resulted in him, the defendant, pushing her down onto the floor.
Yes.
And that's the statement the defendant gave you about conduct involving his aunt.
Yes.
Okay, thank you. And now, Mr. McGranahan, if I could direct you to page 11 of your report.
Yes.
I think in this part, you're going through some of the history of the defendant, is that correct?
Yes. Under the section labeled education.
And in this education, we have listed comments. Are those his comments to you?
Yes.
And if you would go through those comments for us, please.
We discussed his elementary school years. He admitted that he got into fights. He couldn't count how many fights. He also admitted that he did have anger issues. And of course, again, he readmitted that he had an aggravated assault charged against him against his aunt.
Thank you. And now, Mr. McGranahan, if I could direct your attention to page 14 of your report.
Yes.
And at the top of the page, I believe you are now gathering some of the defendant's health information, is that correct?
Yes.
Okay. And this, again, this information is coming directly from the defendant to you.
Yes.
And what does he state under comments under health information on page 14?
He told me around age 16 he was referred to a mental health cooperative because he told his stepmother that he wanted to kill her and that he wasn't sleeping. He was about age 19 at that time.
So in going through your assessment and evaluation with the defendant, he's already alluded to several incidences of his anger and outburst as a juvenile.
Yes.
Is that kind of common throughout what you saw in your pre-sentence report?
Yes.
Okay. And then next, Mr. McGranahan, at the bottom of the same page, under alcohol and drug use, what did the defendant tell you regarding his alcohol and drug use?
Well, he said he didn't have an issue with alcohol or drugs. When I asked him questions about his alcohol use, he did admit that he consumed some alcohol. About age 21, when he purchased a bottle of wine, he would consume vodka every now and then, screwdrivers very rarely. Would consume a glass up to a few shots. Admitted that he would get tipsy, and but he said he would not get super drunk. Mostly favorite drink was cherry vodka. Would consume mostly at celebratory moments such as passing a test or completing tasks, things of that nature.
And Mr. McGranahan, did you take him as being truthful when he advised you that he had, in fact, consumed alcohol, but that he didn't have a problem with it?
I did.
And Mr. McGranahan, were you familiar or have you been familiarized with the statement that the defendant gave to Dr. Kimberly Brown of Vanderbilt Medical Hospital?
No.
So you're not aware of what he told her in the alcohol and drug use component?
No, I was not.
All right, thank you. And if we could now go to page 16 of your report. And in this, Mr. McGranahan, are you, and by the way, this copy we're seeing on the screen is my personal copy.
Right.
It's not the copy we've provided to the court, so it doesn't have highlights and handwriting in it. But who told you that Joseph never had a girlfriend until he met Krystal?
His father.
What did the defendant tell you?
He didn't say anything about having girlfriends or not having girlfriends, so I wouldn't know what his answer would be.
Were you aware that in the some of the issues he had as a juvenile, that one of his threats of suicide was when he broke up with his girlfriend?
No.
Would that make a difference to you in your assessment had he told you that he did have a girlfriend?
Yeah, it would. I would like to further explore that.
And above that, under the comments, it says, in a phone interview with Ms. Belle Daniels, she inquired of her relationship with the defendant. She said there were no issues with him.
That's what she said.
Is that accurate?
I always take it with a grain of salt when a family member tells me something like that. But that's what she said. She said they got along. Again, I have some issues with that.
Okay. And if we could go to page 18 of the report, please. And Mr. McGranahan, at the bottom of page 18, it looks like you are completing some employment information and background about his previous employment.
Yes.
And under comments, it says the defendant has had multiple employments in the last 10 years. Is that
Yes.
correct? And this first one that you listed as Office Depot, did the defendant advise the reason that he left the employment at Office Depot?
Yes.
And what did he tell you?
He said he left their employment because due to his mental health. He said he had a nervous breakdown, was crying and screaming. And of course, his manager told him to submit a 2-week notice.
Okay. And on page 19,
Yes.
at the bottom of the page, he advised that he worked for Plum Choice, is that correct?
Yes.
And what was the reason that he advised that he left Plum Choice?
He advised that the reason why he left was that he found what he called an at-home gig to work.
And then the very last sentence on page 19, he said he left employment.
I'm sorry, I looked at the wrong one.
That's okay.
The Plum Choice, I want to correct that. I was looking under IBEX Lowell, I'm sorry. Plum Choice, he said he left because he had health issues, he kept passing out.
Kept passing out?
Yeah, I'm sorry about that.
And then page 20, if I could direct your attention to the next to last paragraph, which would be the paragraph above military information.
Okay.
And it says, according to the defendant, during the interview at Riverbend on July 22nd, he contended that he left their employment because of mental health reasons.
Yes.
Is that what he told you?
Yes.
And that he was experiencing delusions and believed that people were talking behind my back?
Yes.
And these, again, this is information being provided to you by the defendant.
Yes.
And page 22. Now, you interviewed the defendant's biological father, is that correct?
Yes.
And did you also interview his stepmother?
Yes.
And do you remember her name?
Belle, he called Belle, B-E-L-L-E. I think she goes by Niva, N-I-V-A.
Belle Daniels?
Yeah.
Okay. And in the summary that you have here on page 22, near the last sentence of that large paragraph, it says both parents reported no disciplinary issues with the defendant, that they got along.
That's what they said.
That's what they said? Okay. And going to page 23,
Yes.
and we're near the end of the second paragraph, and I think you've typed that there was an admission by the defendant's father. Is that speaking of Joe Daniels, the father of the defendant?
I'm trying to find where you're at.
Okay.
Here. Sorry.
And I've also got it on the
okay,
screen
yes.
here, too.
Yes, it's from the defendant's father.
What does the defendant's father tell you?
He said that Krystal would get violent, and that he would intervene and get what he said, violent with her to protect the kids, and that even his son Joseph Bray would also get violent to protect the kids.
So both the defendant's father and the defendant would get violent towards Krystal?
Yes.
Okay. And then finally, Mr. McGranahan, on page 24,
Yes.
let's start with the paragraph that begins with the word lastly.
Yes,
Can you read, and this is your summary of everything you've gathered, is that right?
right.
And can you read beginning with the word lastly down through the entirety of that page, please?
Yes, it says, lastly, what appears to be an underlying issue throughout the defendant's life was his mental health. The defendant does have a history of mental health dating back to his childhood, where he was first diagnosed as ADHD and bipolar and placed on antipsychotic medications. His history reveals episodes during his junior and high school years where he suffered from depression, nervous breakdown, and threatening to kill his stepmother, and as an adult where he had committed suicide.
All right, let me stop you right there. So, in the course of this interview, I mean, both his father and stepmother said that they didn't have any problems with him, but at the same time, he, by his own admission, he threatened to kill his stepmother.
Yes,
That- What
Yes.
were your thoughts on that?
the thought is that he did have mental health issues, and I don't want to say they minimize that, but I think they're talking about the personal relationship between him and them that there were no problem with, but not necessarily his mental health. So I think they kind of compartmentalized there. You know, their relationship with each other was fine, but he did have issues.
Okay. Continue to read, please.
Let's see. I'll start with his history reveals episodes during his junior and high school years where he suffered from depression, a nervous breakdown, and threatening to kill his stepmother, and as an adult where he attempted suicide. The defendant has been hospitalized several times at Skyline Medical Center, Horizon Hospital, and Vanderbilt University, and he had been receiving services through Dickson County Mental Health Co-op. He reportedly was seeing a therapist in 2016 but lost interest. The last mental health report for the Dickson County Mental Health Co-op was April 3rd, 2018, which stated that he was stable and his current current medication. You want to read further?
Yes, sir, please.
Okay. This defendant appears to have had a solitary upbringing, was not very well accepted in school, and only found acceptance in band until he was told to drop out in academics. He was not very outgoing, had no girlfriends until he met Krystal, lived in a rural setting, did not maintain employment, and finances were tight. There were problems within the marriage involving physical, verbal, and mental abuse. There were allegations of one spouse abusing drugs. There was the stress of raising 3 young children, one of whom was autistic and nonverbal, which by the defendant's own admission he was hard to deal with. Together with what appears to be a lack of or failure to use appropriate coping mechanisms, compounded by all the issues and stresses of his own mental health, the defendant snapped, and it cost the life of his child.
And let's go back to that final 2 lines of your summary.
Yes.
You conclude that the defendant snapped and it cost the life of his child.
Right.
Were you able to do a cursory review of the defendant's grades and educational background?
Yes.
And what did you find to be his educational history?
He did well academically. He made A's and B's. He graduated from high school. He did attend college, did get a technical degree from the Tennessee School of Applied Technology, and also attended National State. So he's quite educated and very intelligent.
Okay. So, Mr. McGranahan, I want to go back now and talk about some of the issues that perhaps because of their relationship were maybe mitigated a little bit in your evaluation of his problems starting in high school through his adult years. Did you at all discuss his hospitalization for threats to blow up his father and stepmother?
We just briefly talked about the issue with his stepmother, that he, had said that he was threatened to kill her, but we didn't go in depth.
Okay. Well, were you familiar with the assessment in which the client had several homicidal ideations directed towards his parents, including a plan to make a bomb and set it off when they were sleeping?
No.
Did you discuss with him his plan to break the noses of his parents and to kill them?
No.
Did you discuss with him his plan and documented mental health history of having a plan to kill his school peers via strangulation and biting off their noses?
No.
He didn't tell you any of this?
He did not.
Did his father or stepmother tell you any of this?
No.
Did he discuss at any length the history of anger management issues and homicidal ideations?
He did not. He did admit that he had anger issues, excuse me.
But he did not discuss the homicidal ideations and his
No.
plan to use some chemicals to blow up his parents' house.
No.
So, Mr. McGranahan, are you familiar with this document?
No, I am not.
Okay. And what is the title of that document?
It's Youth Villages Specialized Crisis Services Assessment Summary and Recommendations updated August 2005.
I'll move that as the state's exhibit number 2.
The exhibit,
Your Honor,
pardon?
objection, he's not familiar with it. He said he didn't recognize it, didn't know what it was, and now they're entering it as an exhibit with no foundation.
I'm moving it as reliable hearsay, Your Honor. It's a signed document provided by a medical provider that was gathered and provided to us by the defense.
Well, I think that there's still, even reliable hearsay does require it to be reliable. Mr. McGranahan, have you ever seen this document before?
No, I have not.
All right, and at this point, do you have any way of authenticating or knowing whether that's an accurate or true copy?
I do not.
And I don't have to sustain the objection for this witness to
That's fine.
introduce that document.
Not a problem. Now, Mr. McGranahan, are you familiar at all with the mental health records that have been subpoenaed from the mental health cooperative in Dickson County, Tennessee?
I'm aware of it, but I have not looked at that entire record. I do have the last copy of a mental health record from Dickson Mental Health from April of 2018.
And Your Honor, I'm going to move these as the state's next exhibit. Attached to it is the affidavit of the custodian of records from the Mental Tennessee Health Cooperative stating what's true and correct within this subpoena.
But I have to raise the same objection, Your Honor. Mr. McGranahan says that he's aware that they exist, but has never seen them, hasn't looked at them, doesn't know anything about them, and can't verify their authenticity.
Unlike your prior objection, though, this objection will be overruled because that is a raft of documents that was subpoenaed and have been submitted according to the Business Records Exception Act with the affidavit of the custodian of the records. So they would be admissible without authentication by this witness. So overrule the objection.
And I would proceed with moving that as Exhibit 2.
That is Exhibit 2.
Thank you. Now, Mr. McGranahan, although you're not completely familiar because there's thousands, or not thousands, but hundreds of documents that were a business record of the Mental Health Cooperative, you have made some passing reference to things that the defendant has spoken to you about. Is that correct?
Yes.
Now, what I've done is redacted and retracted some of those records to make this a little more efficient.
Yes.
And hand you copies of some of the records.
Yes.
And I'm going to refer you to those records as we see them on the screen. And I'm going to start with page 1 of this, of the first document of the Mental Health Cooperative Notes.
Yes.
And this, the date on this is from,
Officer Cox.
the date on this document is, do you see the date?
That's from 10/6/2015 to 4/1/2020.
Yeah, and I'm looking specifically at the date right there.
Oh, I'm sorry. Yeah, 5/11/2017. I'm sorry.
And I'm going to go through these rather quickly, but the computer monitor keeps flashing in and out. But I've got a portion highlighted in the narrative from the Mental Health Cooperative. Can you read that?
Yes.
Okay, what's it say?
You want me to read the highlighted part?
Yes, sir.
Okay. Client reports past psychosis of aggression, anger, and then quotation marks. I don't remember a lot of it, but apparently I told someone I wanted to eat their face off.
Okay. And I will go to the next page, please.
Yes.
And under the narrative, it says, can you read that for us, just the first sentence?
Yes, client called case manager, I'm assuming see him as case manager, stating that he needs some legal assistance due to his dad being mentally abusive to him and his wife.
So in this particular document, the client, which is Joseph Daniels, is saying that he needs some legal assistance because his father is being mentally abusive to him
Yes.
and his wife.
Yes.
Okay, and what is the date on the top of this document?
March 27th of 2017.
Thank you. And the next page, please. Can you read the highlighted portion there?
Yes. Client stated his anger has increased since the last case manager visit. Client stated that he got very angry yesterday and hit himself.
Thank you. The next page. In the highlighted portion?
Yes. Client stated he is, Client stated he is been walking and listening to music as coping mechanisms when he gets angry.
Thank you. And the next page?
Client stated that he almost had a relapse. Client said that he got upset with a car insurance people. Client said that he got angry.
And the next page?
Yes. He reports being on top of a cliff for 4 days. He states that he attempted SA by strangulation. His wife had to remove the belt.
And the next page?
He's still having agitation, extremely angry. He has had thoughts of hurting others.
In this notation, it says has had thoughts of hurting others.
Yes.
Okay. The next page?
Client reports he was experiencing HI yesterday and left his home to calm down. Client said that this rarely happens, but when it does, it scares him. Client says he did not act on his HI and is not experiencing it today.
Next page, please.
He has felt an increase in his anger, stress, and anxiety. Client said that he feels more irritable. Client said that he has been arguing with everyone in the house. Case manager said client what he felt was triggering the anger. Client stated that he feels overwhelmed with his job and the testing that his son needs.
And when he refers to the testing that his son needs, do you know what he's talking about there?
Not specifically. I do know that his son was receiving services both at home and at school.
Thank you. And the next page?
IPMHAX, I don't know what those stand for. IP in Vanderbilt in 2005 for 2 to 3 weeks. States for HI plan to bomb his own home.
Plan to bomb own home.
Yes.
And the next highlighted portion?
Reports to drink wine on occasions.
Next page?
Client had an outburst of anger last week, told stepmom he was going to tie her to the bed and beat her.
And let me refer you back to when you interviewed Miss Bell Daniels. She didn't mention that to you, did she?
She did not.
Okay. Next page. Right there.
Client reported anger is the problem. Client had an outburst of anger last week, told stepmom he was going to tie her to the bed and beat her. Client report getting loud when angered.
Okay, and just for clarification, that's not a second incident of him wanting to tie her to the bed and beat her. That is a referral back to some notes within this assessment.
Correct.
Next page.
Client reports he made the decision to return to services. DT having severe anger problems. Client reports increased anger outburst, denies any pattern to his anger and feeling very frustrated by it as he has trouble controlling it.
Thank you. The next page.
Let's see, lots and lots of anger. Client reported that he is hoping to get back on some medication to help control his anger.
Next page.
Client CO feeling sad, fatigued, angry, worthless, hopeless, racing thoughts, plus PXS, sleeping and exhausted. Client said he's angry a lot. Client reports he goes from being happy to being really angry. Client states that he has a lot of heated arguments with his mom.
Next page.
Stepmom states that whenever client doesn't get his way at home, he says he's going to kill himself. Stepmom states the client has had this behavior for about past 3 years. Stepmom states that client often gets angry when he doesn't get his way. Stepmom states that client is aggressive toward her but punches the wall and sometimes throws things. Stepmom states client shows no remorse for his actions.
So just to clarify, the note says stepmom states that C is not aggressive toward her, but punches the wall and sometimes throws things.
Yes.
And stepmom C states C shows no remorse for his actions.
That's correct.
Next page.
Client reports doing well at school. Client reports an incident where he put his hand through glass on a cabinet. Client reports he was angry because his parents weren't able to go to parent-teacher conference.
Thank you. The next page.
Client and mom talked about incident that occurred last week when client became angry while at home. Client states that he punched holes in the wall, and mom reports he was very disrespectful towards her.
In this particular one, you read that client states that he punched holes in the wall, and mom reports he was very disrespectful.
Yes.
Next page.
Client stated that C's aunt had accused client of hitting her and slamming her head into the floor.
And do you know if this is referring to the juvenile incident which he was charged with aggravated assault?
I'm not sure if that's referring to it or not. I can't answer that.
Okay. And the next page.
No angry outburst the other day. An anger outburst the other day.
And the next page.
Let's see. I've had some homicidal thoughts.
And the next page.
Clients say that client's friends are called everything from thug to slut by client's parents. Clients say that client was having homicidal thoughts. Case managers asked client to tell case manager about those thoughts, and client stated, I just want him to drop dead. Client said that the client woke up this morning and just got angry as soon as I woke up. Case manager asked if client had a plan. And client stated blow up the house. Case manager asked if client had the potential to do that, and client stated that the name of a chemical that would work, but that's thousands of dollars. I couldn't afford that. Case manager stated that case manager was worried about client's homicidal thoughts, and case manager explained to client that case manager would be recommending other counselors come to the school to evaluate client for possible hospitalization.
The next page.
Mood depressed, sad, notes that he would, quote, rather be 6 feet under. Recently, last week, threatened to burn the house down and then kill himself.
Next page.
Has threatened to burn the house down with all of us in it.
And the next page.
Okay. Joseph states that he's worried about his explosive anger episodes. He says he has been suffering from out of control anger ever since he was 7 or 8 years old, and has just continued to get worse. He has been known to be violent, and he has thrown things, punched holes in walls, and at times tends to overreact, especially when he does not get his way. Then he says that although he realizes this is inappropriate behavior, he usually does not experience remorse for his actions. He also notes that in between these episodes, his mood is usually mellow and not angry.
Page.
Let's see. His mother notes that his mood does change dramatically during these periods, which last anywhere from half a day to a few days, but less than a week.
Next page.
Client's mother talked about client being angry at all time. Client said that he had temper, and the other kids at school were scared of him.
Thank you. And the last page.
Yes. He becomes enraged and will throw things and punch holes in walls. Client states that he at times has no memory of what he has done afterwards. His stepmother states that he overreacts when he does not get his way if something does not go the way he would like.
And let's go back to that one more time. It says he becomes enraged and will throw things and punch holes in walls. Client states that he at times has no memory of what he has done afterwards. Now, does that sound familiar to you, Mr. McGranahan, in talking to the defendant and asking him about the crime that he's been convicted of?
Yes.
What does he tell you about the crime that he's been convicted of?
Well, first of all, when I spoke with him, and per his written statement, he claims he didn't do it. In fact, in my report, I wrote down what he had written down. He believes that his son is still alive.
And you've also heard through your investigation in this case that he has no memory, that he claims to have no memory of what happened because he blacked out.
Yes.
Thank you. Your Honor, if I could have just 1 second. Oh, and I will make an exhibit of these excerpts from the mental health records.
All right, is that the summary that you've been referring to? That would be Exhibit 3.
I'll pass it with this.
Cross-examination?
Mr. McGranahan, in your report where you give the defendant's version, that's not what he was telling you happened when you interviewed him, is it?
And the defendant's version is what he had given me in his personal questionnaire.
So when you say in his version he admitted that he did more than spank him, Joe, and that he threw him on the floor, hit him when he was on the floor, threw him on the coffee table, you're saying he told you he did that?
And if you look on page 6, in the middle, it says, in the personal questionnaire of June 12, 21, as completed by him, this is what he told me in that personal questionnaire, and I reread that to him to make sure I understood him.
And there he told you he was an innocent man.
Yes.
Up above that, in the defendant's version, that is from where you viewed statements and discovery and that type of thing.
Yes.
Okay, so in preparation for this sentencing, he didn't tell you that he killed Joe Clyde Daniels.
No, he did. He said he's an innocent man. That's what he said.
All right. So that part of the defendant's version is above the line of asterisks. That part above is not what he told you.
No, that's from the polygraph interview.
Okay. And on page 7, Alex told you that he saw his father, the defendant, appearing to stab Joe Clyde Daniels. Is that correct?
On page 7,
Yes.
that is from the investigation report from the TBI, okay, dated April 11th, 2018, as prepared by Joseph, the case agent and author of Grant Holt and Joseph Boyd.
All right, and in that version that Alex gives, he indicates that there's a stabbing that took place outside,
Yes,
and that he saw blood on apples.
yes.
And does that version strike you as unusual in any way?
As unusual, I would say that as for a child of his age seeing something traumatic, I think that's the best way he interpreted it.
And you don't believe that he can teleport outside, do you?
No.
Okay. And as far as you know, there's been no evidence in this case of a sword or a knife being used to kill Joe Clyde Daniels.
I am not aware of it.
On page 8,
Yes.
Krystal's Daniels' version was that Joe Clyde Daniels took the body off in a vehicle.
You said Joe Clyde Daniels took the body off. You mean Joseph?
I'm sorry, that Joseph Daniels took the victim, Joe Clyde Daniels, off in a vehicle.
Yes.
And Noah also said that Joseph Daniels put Joe Clyde in the car, down underneath it.
Yes.
Okay,
All this is from the TBI investigation reports.
all right. Nothing further, Your Honor.
Redirect. Thank you, sir. You may step down. You may have a seat in the courtroom if you'd like. State may call your next witness.
Judge, can we have just a minute to run the cable?
Certainly.
The TV keeps.
If that'll stop it from glitching, we hope.
Can I avail myself of the restroom while they're hooking the cable?
You may.
Take it out of that computer and put it in yours.
Thank you.
Mr. Etheridge, you still need more time?
No, sir.
All right, General, I believe we're ready for your next witness.
State House Detective Daniel.
Step up, Detective Daniel, raise your right hand.
solemnly swear from the testimony you give in this case, be the truth, the whole truth, nothing but the truth, so help you God.
Detective, will you state your full name for the court, please?
Jonathan Trevor Daniel.
Thank you. And Detective Daniel, you're employed by the Dickson County Sheriff's Office?
Yes, sir.
And you were assigned to this case?
Yes, sir.
And you were also a witness at the trial in this case?
Yes, sir.
And at the trial in this case, we played portions of an interview, not of an interview, but of a recording that you made, is that correct?
Yes.
And you made a recording of the defendant's spontaneous comments at, when did that happen?
The night of April the 6th, well, when we left. It was after the polygraph examination, then we went out to McGranahan Road.
Okay. And portions of that, of the defendant's statements were played at trial, but there were some portions of his statements that were not played, is that correct?
Correct.
And if I could have Mr. Etheridge bring us to a portion of this recording, and you made this recording, is that correct?
Yes, sir.
Okay.
I had this happen before. You have? When did you kill anybody? I don't remember what happened in high school, but I woke up in Vanderbilt. What? When did, what happened? I know you said you don't remember what happened, but what was the end result? Well, what was wrong with you? I had, I guess just lost, what they call judgment. I didn't really remember what I said to anybody. But you were in Vanderbilt, so you were hurt, right? That was a psychiatric ward. Oh, okay, that part of Vanderbilt? Yeah. Oh, okay. What about the other person? Was there, did something happen? No, no one got hurt. Okay, that's good. But apparently I told somebody that I was going to blow up my house and I was going to eat someone's face off. And, really? Yeah. Wow. At school, or what? Do you remember where it happened at? Apparently it was at school. When I got out and went back to school, the principal took me to the office and said I should expel you right now, right here, and not let you come back. because of what happened.
Yeah.
And then I heard some other things, and that was mostly just rumors.
Yeah.
But I thought that was a lot of things. And going back again to Sky, Madison, because I attempted suicide.
How'd you attempt it?
Tried to strangle myself.
Tried to strangle yourself? With what?
Belt.
Did you hang it somewhere, or is it just you just trying to do it manually?
Manually.
Yeah. Did you pass out?
Almost. My wife had to take the belt off my. She almost took it off. Yeah, Krystal.
Detective Daniel, did the defendant say that he was committed to the hospital because he had made statements that he was going to blow up his house and eat someone's face off?
Yes, sir.
Did he also say that I don't remember what happened?
Yes, sir.
Did he also at the end there talk about one of his attempts to commit suicide?
Yes, sir.
Do you remember from this interview what prevented him from killing himself in that particular occasion? He said someone took the belt off.
His wife.
His wife, Krystal,
Yes.
took the belt off from around his neck.
Yes.
And I'll move a copy of this recording as the next exhibit.
Exhibit 4.
I'll pass the witness.
Cross-examine.
No questions, Your Honor.
Thank you, Officer Daniel. You may step down and have a seat. State may call your next witness.
State rest.
State has rested, Mr. Lockhart.
Your Honor, the testimony that the court has heard so far puts at issue even more the circumstances of this crime, how it took place, what, if anything, our client did before or after. And again, the only fact witness that we are aware of that can testify to what my client did before, during, or after that go to any of these factors is the child in this case that we subpoenaed. So I would request that this be, we go in recess till we can get him here, or the court convene this on another day, because he is the only witness. There's not another witness who says they saw this take place.
Judge, the proof that the state just put on had zero to do with the facts of the crime. The state was putting on proof of the dangerous nature of the defendant. We put on, as I said, the mental health records of the defendant, which have nothing to do with the juvenile. The juvenile was not one of these mental health visits. Not one. He wasn't even alive for some of them. The last witness is a recording about statements that the defendant made at some other instance of conduct, have nothing to do with the juvenile. The state put on zero proof about the facts of the crime that the defendant was committed. Now, Mr. McGranahan's report does include various pieces of evidence and statements that he himself constructed to complete the report, but that's not part of the state's offer of proof in this case.
All right, we'll take a short recess. Let me review I'm going to review the case law on this issue and see if I can make a determination of the correct ruling, and then I will return, hopefully in a few moments.
All right. This court is in recess.